Professional ethics. Who is an advocate? Ananta. Procedure for admission of an advocate to legal profession, enrollment, qualification, disqualification. Who is an advocate? Advocate is a person authorized to appear in litigation on behalf of a party. Advocate should possess a law degree and is enrolled with the Bar Council as prescribed by Advocate Act 1961. Advocates are the only class of persons legally entitled to practice law. Advocates provide legal advice to clients. In the legal system, an advocate represents his client in a court of law. An advocate is the most important part of the legal system of any country. He is solely responsible for the presentation of the case and to bring justice to the victim through his arguments. The court of law passes its judgment based upon the facts and arguments presented by him. After being authorized to appear in a case by a client who has signed a wakalatnama, advocates prepare cases and argue them in court. In Bombay and Calcutta High Court, there is a separate class of legal practitioners known as solicitors who prepare the case but do not argue in court. When appearing in courtroom, an advocate usually dresses in black and white and wears a band and a gown. Any complaint against an advocate is made to the Bar Council of India. Legal definition, Section 2 of the Advocates Act. In this act, unless the context otherwise requires, advocate means an advocate entered in any role under provisions of this act. How to be an advocate, that is enrollment. Step 1. Bachelor's degree LLB. To become an advocate in India, it is compulsory for a person to complete his bachelor's degree in law, that is LLB, Legum Baccalaureus. Legum Baccalaureus. The bachelor degree of law can be either of a 3-year or a 5-year. 3-year course or 5-year course, 10+2. Enrollment in State Bar Council. The final step to be an advocate is to enroll in any of the state bar councils regulated by the Advocate Act 1961. Every state has its unique process of registration. Once registration is completed, the candidate has to clear the All India Bar Examination. The examination is conducted by Bar Council of India and the candidate gets a certificate of practice upon clearing the exam. The test is conducted to assess the basic analytical capabilities and knowledge of law. Criteria for enrollment as an advocate as per Section 24 of the Advocates Act. A person shall be qualified to be enrolled as an advocate if he fulfills the following conditions. He is a citizen of India, provided that a national of any other country can also practice only if Indians are allowed to practice in that other country, that is a reciprocal basis. He has attained the age of 21 years and he has completed his bachelor's in law. He has paid the required stamp duty or is chargeable under the Indian Stamp Act and an enrollment fee payable to State Bar Council. He has to pay 600 rupees to the State Bar Council and 150 rupees to the Bar Council of India. If such person is a scheduled caste or a scheduled tribe, then he has to pay 100 rupees to the State Bar Council and 25 rupees to the Bar Council of India. Qualification and registration role of advocates. According to Section 24, the person must be a citizen of India, first and foremost condition for enrollment in India. Then nationals of other countries can be allowed on a reciprocal basis. Person must have completed age of 21 years. It is a vital condition for enrollment. The person who wants to register. Person must be law graduate, has got the law degree. Payment of decided fees 600 rupees and 150 rupees. And stamp fees, fulfillment of other conditions. Disqualification. Section 24A of the Advocate Act describes the disqualification. The person is held guilty for a crime related to moral turpitude, disqualified. Held guilty, okay. A person is held guilty under Untouchability Act. If the person has been dismissed from the post from employment office under state on the blame of moral turpitude, the qualification will remain effective. Disqualification will remain effective for 2 years from the date of such removal. Solicitor firm. Solicitor advise clients and draft pleadings and documents, but engage advocates for conducting the case in the court. Lawyers who want to be solicitors should pass an examination. In India, a 2-year practice is also required before an Indian lawyer can qualify as a solicitor. A solicitor can cover a large clientele unlike the advocate. Mostly solicitor works Solicitors work on a retainer basis for large companies for handsome remuneration. Commercial clients call in solicitors for advice on matters including litigation, property, tax, and finance. Private client work usually involves personal legal matters such as wills, property, conveyancing, divorce, and custody. Solicitors' firm comes in all shapes and sizes, so it is important to do your research first and find out which one would suit you. Solicitors need a wide range of skills as well as being able to communicate with clients and develop good working relationship with them. They need to be able to work closely with colleagues, pay close attention to detail, and be willing to work long hours. They also need initiative and good judgment to work with complex information. Discuss the seven lamps of advocacy. Introduction. A profession aims at rendering services and business aims at merely earning profits. A professional is the one who has all the requisite technical knowledge and skills which the field demands. Hence, advocacy falls under the category of profession. People often insult this profession by saying that liars are liars. It is to be noted that the liar argues for his client and not for himself. A liar always presumes that his client is innocent because that is how our legal system works. Presumption of innocence until proven guilty. He argues with the information provided by his client. Thus, advocates should not only aim at putting an end to their client's peril but also aim at uplifting this honorable profession. Seven lamps of advocacy. Justice Abbott Parry has put forward the qualities which are to be possessed by a person who pursues this profession. These qualities are called seven lamps of advocacy, that is, honesty, courage, industry, HCI, Hyderabad Cricket Association, Hyderabad Cricket Industry, then wit and eloquence in the court, wit and then judgment and fellowship, judgment of right versus wrong and fellowship, then you have tact, tact and knowledge and empathy. They are missing. Honesty. A lawyer is expected to be honest at all times, including while delivering his arguments. He is not supposed to master the art of deceiving. He should take utmost care while delivering his arguments, as a judge will rely mostly upon his submissions. He should be a pioneer of dharma and prevent injustice from prevailing. It is he who should uphold justice. His honesty would make him more dependable in the front of the eyes of law and his clients. Courage. A lawyer should be fearless and courageous while upholding his stand in front of the bench. Only a person who is truthful and honest will be fearless at all times. A lawyer should never back off from any situation. He should be bold and witty enough to tackle all the dangers advancing towards him. A lawyer should be bold enough to fight against social evils for the sake of citizens. He should aid in directing and molding society in the right way. Industry. An advocate needs to possess all necessary skill set which is required by this profession. He needs to master the art of both speaking and writing. He needs to work his way towards success. A lawyer should never be ignorant of the law. Ignorance of the law is never permissible. He should have sheer dedication and devotion towards his profession. Law is like the ocean. The more you believe you are discovered, the more mysteries are lined up to be unraveled. Nobody in this world can master law because law evolves continuously. In this profession, who can never achieve mastery, who will always be a pupil, that is student. Wit. A good lawyer should have a lot of wit and presence of mind while he is arguing. Well prepared speech will never work in a court of law. He should make a conversation with the judge. He should elucidate on every significant fact of the case. He should lead the judge with his arguments. It is true that the judge won't be convinced in the first go. He will be asking questions as he is supposed to because he has got the most difficult job to do, that is rendering justice. Intelligence and knowledge are other things which are to be vested in a lawyer. They would come in handy in later stages of his arguments. Eloquence. A lawyer should be a very skilled speaker. He should have the required style and confidence in court. Eloquence adds more effectiveness to his submissions. His language should be more error-free. He should employ the pauses at the right moment. His submissions need not be dramatic, but need to be effective. It should leave an impression on the judge. He should be persuasive. He should be able to reframe his submissions until he wins in his client's favor. A judge should be able to recollect the intrinsic details the advocate pointed out in his pleadings while writing his judgment. That is the level of effectiveness that is to be achieved by a lawyer. Judgment. Before drafting his submissions, a lawyer should be able to anticipate the possible counter arguments that might arise from the other side. He should be prepared to dodge all of the counters. He should be able to assess which detail of the fact or a statute would help him to achieve the desired verdict. There is an old saying, he can't be a good lawyer unless he can't take two sides. This particular skill would make the best out of a lawyer fellowship. Though there is a battle of words in the court of hall, no lawyer is supposed to hold grudge against the other. They should always uphold the fellowship in this profession. That is why lawyers refer to their opposite side counsel as a learned friend. If every lawyer takes it to their heart, that might hinder the fellowship of this profession. It might even lead to its downfall. Conclusion. Thus, lawyers have an important duty of upholding justice in the most crucial of times. They must not only work towards the betterment of this profession but also for betterment of the society. Every lawyer is obliged to serve the society. It is one of his primary duties. The service of a lawyer to the development of the society is indispensable. Next, examine the duties of advocates for the standard of professions. Professional conduct and etiquette. Enumerate the duties of advocates toward the client, courts, and other advocates. Advocate's duty to provide legal aid to poor. An advocate shall at all times comport himself in a manner befitting his status as an officer of the court, a privileged member of the community, a gentleman, bearing in mind that what may be lawful and normal for a person who is not a member of the bar or for a member of the bar in his non-professional capacity may still be improper for an advocate. Without prejudice to the generality of the foregoing obligation, an advocate shall fearlessly uphold the interest of his client and in his conduct conform to the rules hereinafter mentioned both in letter and in spirit. The rules hereinafter mentioned contain canons of conduct and etiquette adopted as general guides. Yet specific mention thereof shall be construed as a denial of the existence of others, equally imperative though not specifically mentioned. Section 1. Duty to the court. An advocate shall, during the presentation of his case and while otherwise acting before a court, conduct himself with dignity and self-respect. He shall not be servile, and whenever there is a proper ground for serious complaint against a judicial officer, it shall be his right and duty to submit his grievance to the proper authorities. An advocate shall maintain toward the courts a respectful attitude, bearing in mind that the dignity of the judicial office is essential for the survival of a free community. An advocate shall not influence the decision of a court by any illegal or improper means. Private communications with judge relating to a pending case are forbidden. An advocate shall use his best efforts to restrain and prevent his client from restoring to sharp or unfair practices or from doing anything in relation to the court, opposing counsel or parties which the advocate himself ought not to do. An advocate shall refuse to represent his client who persists in such improper conduct. He shall not consider himself a mere mouthpiece of his client and shall exercise his own judgment in the use of restrained language in correspondence, avoiding scurrilous attacks in pleadings, and using intemperate language during arguments in court. An advocate shall appear in court at all times only in the prescribed dress, and his appearance shall always be presentable. An advocate shall not enter appearance, act, plead, or practice in any way before a court, tribunal, or authority mentioned in section 30 of the Act, if the sole or any member thereof is related to be an advocate as father, grandfather, son, grandson, uncle, brother, nephew, first cousin, husband, wife, mother, daughter, sister, aunt, niece, father-in-law, daughter-in-law, or sister-in-law. Advocate shall not wear bands or gown in public places other than in courts, except on such ceremonial occasions and such places as the Bar Council and the court may prescribe. Advocate shall not appear in or before any court or tribunal or any other authority for or against an organization or institution, society or corporation if he is a member of the executive committee of such organization, institution, society or corporation. Executive committee, by whatever name it is called, shall include any committee or body of persons which for the time being is vested with the general management of the affairs of the organization, institution, society or corporation, provided that this rule shall not apply to such member appearing as amicus curiae or without fees in a matter affecting affairs of bar council, incorporated law society or a bar association. An advocate should not act or plead in any manner in which he himself is pecuniarily interested. Illustration: he should not act in bankruptcy petition where he himself is also a creditor of the bankrupt. He should not accept a brief from a company of which he is a director. As an advocate shall not stand as a surety, certify the soundness of surety for his client required for the purpose of any legal proceedings. Section 2. Duty to the client. An advocate is bound to accept any brief in courts or tribunals or before any authority in before which he professes to practice as a free consistent with his standing at the bar and the nature of the case. Special circumstances may justify his refusal to accept a particular brief. Advocate shall not ordinarily withdraw from engagements once accepted without sufficient cause and unless reasonable and sufficient notice is given to the client. Upon his withdrawal from a case, he shall refund such part of the fees as has not been earned. Advocate should not accept a brief or appear in a case in which he has reason to believe that he will be a witness, and if being engaged in a case it becomes apparent that he is a witness on the material question of fact, he should not continue to appear as an advocate if he can retire without jeopardizing his client's interest. Advocate shall, at the commencement of his engagement and during the continuance thereof, make all such full and frank disclosures to his client relating to his connection with the parties and any interest in or about the controversy as are likely to affect his client's judgment in either engaging him or continuing the engagement. It shall be the duty of an advocate fearlessly to uphold the interest of his client by all fair and honorable means without regard to the unpleasant consequences to himself or any other. He shall defend a person accused of a crime regardless of his personal opinion as to the accused, bearing in mind that his loyalty is to the law, which requires that no man should be convicted without adequate evidence. An advocate appearing for the prosecution in a criminal trial shall so conduct the prosecution that it does not lead to the conviction of the innocent. The suppression of material capable of establishing the innocence of the accused shall be scrupulously avoided. An advocate shall not directly or indirectly commit a breach of the obligations imposed by Section 126 of the Indian Evidence Act. An advocate shall not at any time be a party to the fomenting of litigation. Advocate shall not act on the instruction of any person other than his client or his authorized agent. An advocate shall not stipulate for a fee contingent on the results of litigation or agree to share the proceeds thereof. An advocate shall not buy or traffic in or stipulate for and agree to receive any share or interest in any actionable claim. Nothing in this rule shall apply to stock, shares, debentures, or government securities or instruments which are for the time being by law and custom negotiable, or to any document or title to goods. Advocate shall not directly or indirectly bid for or purchase either in his own name or in any other name for his own benefit or the benefit of any person any property sold in the execution of a decree of order of any suit, appeal, or other proceeding in which he was in any way professionally engaged. This prohibition, however, does not prevent an advocate from bidding for and purchasing for his client any property which his client may himself legally bid for or purchase, provided the advocate is expressly authorized in writing in this behalf. An advocate shall not adjust fees payable to him by his client against his own personal liability to the client, which liability does not arise in the course of his employment as an advocate. Advocate shall not do anything whereby he abuses or takes advantage of the confidence reposed in him by his client. An advocate should keep account of the client's money entrusted to him, and the accounts should show the amounts received from the client on his behalf, the expenses incurred for him, and the debits made on account of fees with respect to dates and all other necessary particulars. Where monies are received from and on account of a client, the entities in the accounts should contain a reference as to whether the amounts have been received for fees or expenses. And during course of the proceedings, no advocate shall, except with the consent in writing of the client concerned, be at liberty to divert any portion of the expenses towards fees. Where any amount is received or given to him on behalf of his client, the fact of such receipt must be intimated to the client as early as possible. After the termination of proceedings, the advocate shall be at liberty to appropriate towards the settled fee due to him any sum remaining unexpended out of the amount paid or sent to him for expenses or any amount that has come into his hands in that proceedings. Where the fee has been left unsettled, the advocate shall be entitled to deduct out of any monies of the client remaining in his hands at the termination of the proceeding for which he had been engaged, the fee payable under the rules of the courts in force for the time being and by then settled, and the balance, if any, shall be refunded to the client. A copy of the client account should be furnished to him on demand, provided the necessary copying charge is paid. Advocate shall not enter into arrangement whereby funds in his hands are converted into loans. Advocate shall not lend money to his client for the purpose of any action or legal proceedings in which he is engaged by such client. Explanation. Advocate shall not be held guilty of a breach of this rule if in the course of a pending suit or proceedings and without any arrangement with the client In respect of the same, the advocate feels compelled by any reason of the rule of the court to make a payment to the court on account of the client for the progress of the suit or proceeding. Advocate who has at any time advised in connection with the institution of a suit, appeal, or other matter, has done pleadings or acted for a party, shall not appear or plead for the opposite party. Section 3. Duty to the opponent. An advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through the advocate. Advocate shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced to writing and enforceable under rules of the court. Duty to colleagues. An advocate shall not solicit work or advertise either directly or indirectly, whether by circulars, advertisements, touts, personal communication, interview not warranted by personal relations, furnishing or inspiring newspaper comments, or procuring the photograph to be published in connection with cases in which he has been engaged or concerned. His signboard or nameplate should be of a reasonable size. The signboard or nameplate or stationery should not indicate that he has been a president or a member of a bar council or of any association, that he has been associated with any person or organization or with any particular cause or matter, or that he specializes in any particular type of work, or that he has been a judge or an advocate general. An advocate shall not permit his professional services or his name to be used in aid of or to make possible an unauthorized practice of law by any law agency. Advocate shall not accept a fee unless the fee taxable under the rules, when the client is able to pay the same. Advocate shall not enter the appearance in any case in which there is already a wakalat or a memo of appearance filed by an advocate engaged by a party except with his consent. In case such consent is not produced, he shall apply to the court stating reasons why the said consent could not be produced, and shall appear only after obtaining permission of the court. Section 4A. Every advocate born on the rules of the State Bar Council shall pay to the State Bar Council a sum of ₹30 every third year, commencing 1st April 1980, either at one time or in 3 equated installments. The aforesaid sum collected by the State Bar Council shall be credited to a separate fund to be known as Advocate Welfare Fund. All sums so collected by the State Bar Council in accordance with Rule 40 shall be remitted to the Bar Council of India forthwith, which shall be credited by the Bar Council of India to a separate fund, to a fund known as Advocate Welfare Fund. Every advocate born on the rolls of the State Bar Council shall deliver on or before 1st April every year a declaration in the form prescribed. Every advocate born on the rolls of the State Bar Council shall deliver on or before 1st April every year, commencing 1st April, a declaration in the form prescribed. Every advocate born on the rolls of the State Bar Council shall enroll himself as a member of a bar association within the territory over which the said Bar Council exercises jurisdiction. Every declaration under Rule 43 above shall be accompanied by a certificate of the Secretary of that Bar Association, certifying that he is a member, that is paid all dues of the Bar Association. Name of every advocate who fails to pay the aforesaid sums within the prescribed time set out in Rule 40 and fails to file the declaration under 43, makes any false statement in declaration under 43, shall be removed from the rolls of State Bar Council. Before the name of any advocate is removed from the rolls under Rule 45, the Secretary of State shall serve on the advocate concerned a notice to show cause against the removal of his name, and the cause shown, if any, shall be dealt with by the chairman of the State Bar Council forthwith, who in his discretion shall pass such orders as he thinks fit. Section 5. Duty in imparting training. It is improper for an advocate to demand or accept fees or any premium from any person as a consideration for imparting in law under the rules prescribed by the Bar Council to enable such person to qualify for enrollment under Advocate Act 1961. Section 6. Duty to render legal aid. Every advocate shall, in the practice of a profession of law, bear in mind that anyone genuinely in need of a lawyer is entitled to legal assistance even though he cannot pay for it fully or adequately, and that within the limits of the advocate's economic condition, free legal assistance to the indigent and oppressed is one of the highest obligations the advocate owes to society. Section 7. Restrictions on other employments. An advocate shall not personally engage in any business, but he may be a sleeping partner in a firm doing business, provided that, in the opinion of the Bar Council, the nature of the business is not inconsistent with the dignity of the profession. Advocate may be a director or a chairman of the board of directors of a company, with or without any ordinary sitting fees, provided none of his duties are of an executive character. An advocate shall not be a managing director or a secretary of any company. Advocate shall not be full-time salaried employee of any person, government, firm, corporation, or concern, so long as he continues to practice and shall, on taking up any such employment, intimate the fact to the Bar Council and shall thereupon cease to practice as an advocate so long as he continues in such employment. Nothing in this rule shall apply to law officer of the central government or the government of a state of any public corporation or body constituted by statute who is entitled to be enrolled under the rules of the Bar Council made under Section 28 2D read with Sections 24 1C of the Advocate Act, despite his being a full-time salaried employee. Advocate who has inherited or succeeded by survivorship to a family business may continue it, but may not personally participate in the management thereof. He may continue to hold a share with others in any business who has descended to him by survivorship or inheritance or by will, provided he does not personally participate in the management thereof. Advocate may review parliamentary bills for remuneration, edit legal textbooks at a salary, do press vetting for newspapers, coach people for legal examination, set and examine question papers, subject to the rules against advertising and full-time employment, engage in broadcasting, journalism, lecturing, and teaching subjects both legal and non-legal. Nothing in these rules shall prevent an advocate from accepting, after obtaining the consent of the Bar Council, part-time employment, provided that in the opinion of the Bar Council, nature of the employment does not conflict with his professional work, is not inconsistent with the dignity of the profession. The rules shall be subject to such directions, if any, issued by the Bar Council. Professional misconduct. Answer. A lawyer's profession is meant to be divine or sacred profession by all means. In every profession, there are certain professional ethics that to be followed in every person who is unto such profession, but there is a fact that professional misconduct is a common aspect not only in other professions but also in advocacy also. In simple terms, it means that certain acts done by the persons which have been clearly defined in Black's dictionary as the transgression of some established and definite rule of action, a forbidden act, a dereliction of duty, unlawful behavior, improper or wrong behavior. It is synonymous with misdemeanor, impropriety, mismanagement, offense, but not negligence or carelessness. From the definition, it is now clear that an act of a professional misconduct is done purely with an intention of getting unlawful gains. The Advocate Act 61 and Indian Bar Council play a vital role in providing rules and guidelines regarding working, code of conduct, and such other matters concerning lawyers and advocates in India. Attributes of a profession are existence of a body of specialized knowledge or techniques, formalized method of acquiring training and experience, establishment of a representative organization with professionalism as its goal, formation of ethical codes for the guidance of conduct, and charging of fees based on services, but with due regard to the priority of service over the desire of monetary rewards. ఏముండాలంటే బాడీ ఆఫ్ స్పెషలైజ్డ్ నాలెడ్జ్ ఉండాలి, ఫార్మలైజ్డ్ మెథడ్ ఆఫ్ అక్వైరింగ్ ట్రైనింగ్ ఉండాలి, ఎస్టాబ్లిషింగ్మెంట్ ఆఫ్ ఎ రిప్రజెంటేటివ్ ఆర్గనైజేషన్ విత్ ప్రొఫెషనలిజం ఉండాలి, ఫార్మేషన్ ఆఫ్ ఎథికల్ కోడ్స్ ఉండాలి, ఛార్జింగ్ ఆఫ్ ఫీజ్ ఉండాలి ఆన్ వర్క్ బేసిస్. Misconduct, professional misconduct. Misconduct means any acts which are unlawful in nature even though they are not inherently wrongful. Before the Advocate Act 61, we had a Legal Practitioner Act 1879. There is no definition given for the term misconduct in the Act, but the term unprofessional conduct is being used in the Act. Some of instances of professional misconduct are as follows: dereliction of duty, professional negligence, misappropriation, changing sites, contempt of court and improper behavior before a magistrate, furnishing false information, giving improper advice, misleading the client in court, not speaking the truth, disowning allegiance to the court, moving application without informing that a similar application has been rejected by another court, another authority, suggesting to bribe the court officials, forcing the prosecution witness not to say the truth. Advocates Act 1961. The provisions of Section 35 of the Advocate Act deal with the professional misconduct. Section 35 of lawyers and advocates in India, which read as: a person is found guilty of professional misconduct, it shall refer the case to a disciplinary committee, shall fix a date of hearing and issue a show cause notice to the advocate and the Advocate General of the state. The disciplinary committee of the State Bar Council, after being heard of both parties, may 1. dismiss the complaint, or where the proceedings were initiated at the instance of the State Bar Council, direct that proceedings be filed to reprimand the advocate, then suspend the advocate from practice for such period and remove the name of the advocate from the state roll. Misconduct is of an infinite variety. This expression must be understood in a broad meaning such that it extends the meaning under the natural law and there is no justification for restricting their natural meaning. Section 49 of the Advocate Act empowers the Bar Council of India to frame rules and standards of professional conduct. Under this rule, no person has a right to make an advertisement or soliciting. It is against an advocate's code of ethics. He is also not entitled to any advertisement through circulars, personal communications, or interviews. He is not entitled to demand fees for training and to use name or service for unauthorized purposes. Discuss the powers and functions of Bar Council of India. The functions of Bar Council of India. Section 7 of the Advocate Act 1961 provides that the functions of the Bar Council of India shall be 1. Functions of Bar Council of India shall be lay down standards of professional conduct and etiquette for advocates. See also professional misconduct. To lay down procedure followed by disciplinary committee and disciplinary committee of each state bar council. Safeguard rights and privileges and interest of advocates. Promote, support law reform. Deal with the disposal of any matter arising under the Act which may be referred to it by a state bar council. Exercise general supervision and control over the state bar councils. Promote legal education to lay down standards of such education in consultation with the universities in India imparting such education in state bar council. Recognize universities whose degree in law shall be a qualification for enrollment for an advocate for the purpose to visit and inspect universities or cause the state bar council to visit and inspect universities in accordance with such directions as it may be given in this behalf. Conduct seminars and organize talks on legal topics by eminent jurists and publish journals and papers of legal interest. To organize legal aid to the poor in prescribed manner, to recognize on a reciprocal basis foreign qualification in law obtained outside India for the purpose of admission as advocate under this Act. Manage and invest the funds of Bar Council, to provide for election of members, to perform all other functions conferred on it or by the Act, to do all other things necessary for discharge of the aforesaid function. The Bar Council of India may constitute one or more funds in the prescribed manner for the purpose of giving financial assistance to organize welfare schemes for indigent, disabled, or other advocates, giving legal aid or advice in accordance with the rules made in this behalf, establishing law libraries. Bar Council of India may receive any grant, donation, gift to beneficiary for all or any of the purposes specified in Section 2, which shall be credited to the appropriate funds constituted under the subsection. According to Section 7A of the Advocate Act 1961, Bar Council of India may become a member of the international legal bodies such as International Bar Association, International Legal Aid Association, contribute such things fit such bodies by any of the subscription or otherwise, and authorize expenditure on the participation of representatives in any international legal conference seminars. Some of the important functions of the Bar Council of India are as under: admission as advocate. Section 20 of the Advocate Act provides that every advocate who was entitled has a right to practice in the Supreme Court immediately before appointed day and whose name has not been entered in any state roll may, within the prescribed time, express his intention in the prescribed form to the Bar Council, and on receipt thereof the Bar Council of India shall direct that the name of such advocate shall, without payment of any fee, be entered on the roll of the State Bar Council, and the State Bar Council concerned shall comply with such direction. Section 19. In this section, Advocate Act requires the State Bar Council to send copies of the rolls of advocates to the Bar Council of India. It provides that every State Bar Council shall send to the Bar Council of India an authenticated copy of the roll of advocates prepared by it for the first time under this Act, and shall thereafter communicate to the Bar Council of India all alternatives and additions to such roll as soon as the same have been made. Section 18 of the Advocate Act 1961 makes provision in respect of transfer of name from one state roll to another. It provides that any person whose name is entered as an advocate on the roll of any State Bar Council for the transfer of his name from the roll of State Bar Council to the roll of any other State Bar Council, and on receipt of any such application, the Bar Council of India shall direct that the name of such person shall, without payment of any fee, be removed from the roll of the first mentioned State Bar Council and be entered in the roll of the other State Bar Council, and State Bar Council concerned shall comply with such direction. Appointment of committees and staff members. Section 5 of the Advocate Act empowers the Bar Council of India to appoint one or more disciplinary committees, legal aid committee, executive committee, or legal education committee, etc. Section 11 of the Advocate Act empowered the Bar Council to appoint a secretary and accountant and such member of persons as may deem necessary. But secretary and accountant, if any, shall possess such qualification, it is mandatory the Bar Council shall have a secretary. Maintenance of advocates. Section 12 of the Advocate Act requires the Bar Council of India to maintain such book of accounts and other books in the form and manner as prescribed. The accounts shall be audited by the auditors duly qualified to act as auditors of companies, and such at times and in such a manner as may be prescribed. The Bar Council of India shall send a copy of the accountants together with the copy of the report of the auditors thereupon to the central government, and shall cause the same to be published in Gazette of India. Rules making power. The Bar Council of India shall make rules under the provisions of Section 15 of the Advocate Act. Section 15 Clause 2 of this Act provides that in particular and without prejudice to the generality of the foregoing powers, such rules may provide for the election of members of the Bar Council, chairman, vice chairman, election disputes, filling of casual vacancies by Bar Council, power and duties of the chairman, vice chairman, constitution of one or more funds, organization of legal aid, meeting and conduct of business of any committee, management, investment of funds of Bar Council. Section 49 of the Advocate Act confers on the Bar Council of India general power to make rules for discharging the functions under this Act, power to punish for professional or other misconduct. Section 36 of Advocate Act empowers the Bar Council of India to punish an advocate for professional other misconduct like suspending the advocate from practice for such period as it may deem fit and remove the name of the advocate from the state roll. It has the power to dismiss the complaint, reprimand the advocate. Appellate power. Section 37 of the Advocate Act empowers the Bar Council of India to hear appeal against the order of the Disciplinary Committee of a State Bar Council. Every such appeal shall be heard by the Disciplinary Committee of the Bar Council of India. Section 38 provides that any person aggrieved by the order passed by the Disciplinary Committee of the Bar Council of India may challenge within 60 days by way of appeal before Supreme Court. Other powers and functions of Bar Council of India. To give such financial assistance as it thinks fit to the State Bar Council in need of funds for the purpose of performing his function. To prevent a citizen of any country from practicing profession of law in India when that country is specified by the central government in this behalf, prevent citizens of India from practicing law in their country. To call for record of any proceedings from any State Bar Council or committee thereof. To see legality and propriety of such proceedings. To give its own order of any of the committee except disciplinary committee. To give direction to the State Bar Council or any other committee thereof for the proper and efficient discharge of functions of a State Bar Council. Define disciplinary committee and what are the powers and functions of the disciplinary committee under the Advocates Act 1961. Introduction. Section 42 of the Advocates Act provides the powers of the disciplinary committee of a Bar Council. Provisions of this section are the same for both State Bar Council as Bar Council of India. Constitution and composition of disciplinary committee. According to Section 9 of the Advocate Act, a Bar Council shall constitute one or more disciplinary committees such as which shall consist of 3 persons, of whom 2 shall be persons elected by the Council from among its members and the other shall be a person co-opted by the Council from among the advocates who possess qualifications specified in the proviso in subsection 2 of Section 3 and who are not members of the Council. And the senior-most advocate among the members shall be the chairman thereof. Powers of Disciplinary Committee. The Disciplinary Committee of a Bar Council shall have the same powers as are vested in a civil court under the Code of Civil Procedure in respect of the following matters, namely 1. Summoning and enforcing the attendance of any person and examining him on oath, requiring discovery and production of any documents, receiving evidence and affidavit, requisition of any public record or copies thereof, issuing commission for examination of witnesses, any other matter, provided that no such disciplinary committee shall have the right to require the attendance of 1. Any presiding officer of a court except with the permission of the High Court, and any officer of a revenue court except with the previous sanction of the state government. All proceedings made before a disciplinary committee of the Bar Council shall be deemed to be judicial proceedings within the meaning of Section 193 and 228 of Indian Penal Code. And every such disciplinary committee shall be deemed to be a civil court for the purpose of Sections 480, 482, 485 of the Code of Criminal Procedure. For the purpose of exercising any of the powers conferred by subsection 3, a disciplinary committee may send to any civil court in territory to which this Act extends any summons or other process for the attendance of a witness or production of a document required by the committee, or any commission which it desires to issue on the civil court shall cause such process to be served, or such commission to be issued as the case may be, and may enforce any such process as if it were a process for attendance or production before itself, notwithstanding the absence of a chairman or any member of a disciplinary committee on the date fixed for the hearing of a case before it. Disciplinary committee may, if it so thinks, hold or continue to the proceedings on the date so fixed. No such proceeding, no order made by the disciplinary committee in any such proceeding shall be invalid merely by reason of the absence of the chairman or member thereof on any such date, provided that no final orders of the nature referred to subsection 3, section 35 shall be made in any proceeding unless the chairman and other members of the disciplinary committee are present. Subsection 3 of section 35. Disciplinary committee of a State Bar Council, after giving the advocate concerned and the advocate general an opportunity of being heard, may make any of the following orders: may be dismiss the complaint, reprimand the advocate, suspend the advocate, remove his name. Where no final order of the nature referred to in 3 of the section 35 can be made in any proceedings in accordance with the opinion of the chairman and members of the disciplinary committee, either for want of majority opinion among themselves or otherwise, the case with their opinion thereon shall be laid before the chairman of the bar council concerned, or if the chairman of the bar council is acting as the chairman or a member of the disciplinary committee, before the vice chairman of the bar council. Said chairman or vice chairman of the bar council, as the case may be, after such hearing as he thinks fit, shall deliver the opinion, and the final order of the disciplinary committee follows such opinion. Discuss the nature and function of accounting and accountancy. Meaning of accounting. Accounting is recording, classifying, summarizing business transactions in terms of money. Record, classify, summarize. Then preparation of final reports, analysis, interpretation of these reports for the information and guidance of the management and public. Meaning of law. Law is rules made by authority for proper regulation. What is the relation of accounting to law? Many laws are made relating to accounts. Company. Importance of accounting advocate profession. Lawyers practice law for fee, earn income in their profession. They meet with such an expenditure that they have money transactions. Lawyers have to maintain accounts. For this, they should have the knowledge of accounting. As a member of the bar council, he should know the bar council accounting and the legal provisions of accounting of bar council. Advocate must know the accounting of legal service authorities and the Supreme Court Legal Service Committee, as the government allots grant for legal aid to poor and deserving people. Advocates must know the accounting of advocates as per Supreme Court rules. Advocates must know the welfare fund accounting, and the bar councils maintain welfare funds. Provide financial assistance to the needy advocates when they are disabled to earn, and all the advocates are members of the welfare fund. Advocates must know to prepare their own accounts, as every advocate is accountable to his client for the amounts received from him. At the same time, he is accountable to the government. According to tax laws, an advocate is bound to accept any brief in courts or tribunal. Advocate should keep accounts of clients. Advocate shall furnish to the client a copy of the client's account or a demand provided necessary copying charges are paid. While fees has been left unsettled, the advocate shall be entitled to deduct out of all the monies the client's remaining in his hands at the termination of the proceedings for which he had been engaged. The fee payable under the rules of the Act in force for the time being or by then settled, and the balance, if any, shall be refunded to the client. Important branches of accounting and accountancy. Bar bench relations. Next, introduction. Bar bench relation is a law referred to the advocates' cordial relationship with the judges. The bar, advocates, and the bench judges play a key role in administering justice. For the maintenance of the cordial relations between bench and the bar, mutual respect is needed. Bar and bench are two parts of the same system, and when they operate in harmony, without which justice cannot be effectively conducted in courts. Bar and bench. Court hall, where there are cases composed of two parts, namely the position where judges are seated is called the bench. Position where advocates are seated is called the bar. The following bench refers to the judges and the bar refers to the advocates. Bar-bench relations refer to cordial relation between judge and advocates. Faith in judiciary to the general public and speedy justice depends upon primarily on the cordial relation between judges and lawyers, and the role of lawyers is equally important to the judges in the administration of justice. It is their joint responsibility to deliver justice. Bar bench position in administration of justice system. Bar bench play a significant part in judicial administration. According to Justice C.L. Anand, there is no office of such power as the judge is in a state. Judges have power far greater than any of the functionaries. Life and liberty of the common people, personal domestic happiness, wealth, integrity subject to the judges' wisdom and hang on to their decision to the citizens. When there is no protection left in life, when the judiciary is corrupt, freedom dies. There is no guarantee in personal or domestic happiness. The greatest need of a state is a strong, powerful, unbiased, active and competent judiciary. Courts should perform their duties on account of the role of the judges in preservation of the orderly society. Bar bench relations. Administration of justice isn't something that must just involve the bench, it also affects the bar. To preserve the cordial relation between the bar and the bench, mutual respect is necessary. Lawyers and judges have to report one another. Bar is the primary recruiting ground for judges, and they are both a member of the same culture. Bar and bench will have cordial relationship with each other, but due to the nature of duties to be performed by advocates and judges, occasionally funny, often heated, and often harsh, they may enter into dialogues. Scandalizing the court by any lawyer also pollutes the very basis of justice, and such behavior by a lawyer gives disrepute to the whole administration of justice. Advocates' attitude toward the tribunal should be one of universal reverence, regardless of the court's position. Advocates' private opinion about the presiding officer, because he has to preserve the integrity of the judiciary as an institution, he must not demonstrate in his actions. Likewise, it is the judiciary's duty not only to be respectful towards the bar members and to do anything possible to promote the higher traditions of the bar. A lawyer or a judge's uncourteous conduct or wrongdoing can amount to a contempt of the court. There are two forms of contempt of the court, for example, to use the insulting language against a judge, or to threaten him with transfer or removal, or to approach the judge in a loose manner, or to challenge his authority to the questions, or to make scandalous allegations against the judge, etc. It amounts to the court of contempt. He is responsible for his uncourteous act and is punishable by a court for such disrespect. The court's contempt punishment is intended to protect public trust in the administration of justice system. Role of the bar to strengthen bar bench relations. Advocate will take the following steps to improve the cordial relations. We should show due respect to the courts, stop talking ill of the courts and judiciary. They shall support the judges in any case trial by explaining the applicable laws in the right and consistent manner. They should never act in such a way that the judges are annoyed. If judges issue a false order, judge should not be blamed. Upon appeal, they will try to set wrong the right. They should not put pressure or manipulate the judges to receive favorable order. If advocate's treatment of judges is annoying and arrogant, he does not enter into direct conflict with the judge. The matter should be discussed with the judge in his chamber through the bar association and shall request that such misconduct be avoided. Bench's role in strengthening bar bench relations. Judges should follow the practice following steps. Judicial respect. Just as the advocates respect the judges, so should the judges respect the advocates. And judges treat them as brethren. Patient hearing. Judges should hear the case with an open mind and without prejudice. They will behave accordingly to the benefit of justice. They will provide ample time for an advocate to present the case in full. Impartiality. Judges are supposed to act impartially. They are not supposed to act in favor of any one of the prosecutor or the party conflict. Avoidance of interruptions. Judges have to avoid interruptions wherever possible. While the lawyer interviews witnesses or presents the argument, advocates may be offended by unwarranted interference and negative remarks from the judges, and thus he may not be able to present the case properly. A judge's intervention may be limited to the following factors: to avoid repetition and time wasting, to check pertinence for clarification, to share an opinion of the court on one point and promote swift disposal of the case. Proper interpretation. In the course of the administration of justice, the courts frequently have to interpret the law, rules, codes, regulations, directives, notices, circulars, bylaws to assess the real meaning of the statutes or to eliminate the confusion or incoherence. In these cases, a proper explanation should be provided for the purpose of making the parties full justice. Avoiding unreasonable adjournments. Adjournments are granted to provide the parties with a reasonable opportunity to present the matter. Without fair and appropriate grounds, cases shall not be adjourned where possible. Unreasonable adjournment is the main reason for the mounting areas of cases that cause parties to suffer hardship. Speedy disposal. Justice deferred is justice denied. Will also be disposed of when justice deferred is justice denied and will also be disposed of as soon as possible. When preferential disposal of old cases is given, new cases should not be in arrears. Avoiding unwarranted comment. Judges should not make unwarranted open court comments about lawyers' lack of knowledge of the law. They shouldn't ask any lawyer to leave the trial without justification enough. Likewise, they should not ask any advocate not to come hereafter to his court. Knowledge of law. Judges will have a deep knowledge of law. We should be able to apply the correct legislation to evidence at hand and make the right decision. రాత్రి ఎన్నిసార్లు లేచాడు? రాత్రి గంటకి ఎన్నిసార్లు? తక్కువ ఎక్కువ? బెయిల్ పనిచేస్తుంది, పొద్దున్న కూడా ఇస్తున్నాం. Independence. The primary responsibility for maintaining and retaining judicial independence rests with judges. Integrity. A judge shall be morally responsible and honest. He should have dignity in both individual and intellect. Character and action should be deserving praise. Industriousness. This means hard work and research frequently and systematically. Judge should get to know the latest development and changes in law by regularly updating his knowledge. Meeting of judges and lawyers. At regular intervals, meeting of judges and advocates are scheduled to improve the bar bench relation. Problems of respective sides can be addressed in these sessions. Disagreements can be worked out. Conclusion. The colonial system of judicial courts has not fully developed into a representative democracy. It is therefore clear that the principles and thus the relationship between the bar and bench have not fully evolved as equally responsible functionaries for the proper discharge of legal justice. What the current situation demands are cordial and mutually respectful bar and bench with high aspirations of people's welfare and the protection of the constitutional, fundamental, and human rights of the aggrieved person, citizen, and others. As the bar and bench connect, they should not forget their own long-lasting integrity and dignity. At least man you must imagine. Our father of the country was also an advocate, and his dream was also. He too was both revered and tried for contempt by judges of Indian judiciary.